This is the Alternative Investing Advantage podcast from Advanta IRA, where we show you how to explore investments beyond Wall Street and open your eyes to new options for your portfolio. It's time to take control and give yourself the freedom to choose where you invest your money.
Edition of the Alternative Investing Advantage podcast. My name is Alex Perny, and today on the download, we have quite the tumultuous market moving happening yesterday and starting this morning as well as of the recording on 3/8 of this podcast. The S&P 500 saw its worst day since October 2020 yesterday on Monday, 3/7, which was not necessarily unexpected, but definitely was more of a move than we had kind of been anticipating. The NASDAQ also seeing a wild swing of almost 2.4% on the day for trading. So the situation in Ukraine with the conflict with Russia is certainly still first and foremost in almost every investor's mind right now, especially when it comes to equities markets with the ever-changing landscape that is kind of coming to fruition with regard to what this is going to mean for the global economy on the short and long-term scale. Financial forecasters from several large investment firms are starting to cut futures forecasts for the S&P 500 index funds that are listed on many of the large investment firms. So definitely kind of a cautionary trend on short-term investing right now. Obviously, long-term investors looking for maybe long-term stability should be looking at alternatives to equities markets, as these shocks are going to be relatively consistent probably through the short term. It's going to be very hard to say with regard to updating sanctions in this conflict and other things happening as to what potential short-term returns can be gained from the market. So certainly time to start shifting into looking at maybe a longer-term strategy, or what is the longer-term investment play going to look like for you, as the short-term is going to be really anyone's guess at the moment. The European markets are on the rise as of trading this morning and midday, as it is about 10:30 on 3/8. So getting towards the end, if not the closing of the days over on the European markets, mainly due to joint defense spending that is going on between European countries in support of mainly Ukraine going into defense spending. Obviously, NATO has still stayed out of the conflict directly, but other European countries seeing it as a sign of support, and the markets reacting accordingly with more spending and exports of things like weaponry and raw materials to Ukraine in support of their fight on that front. Gas prices are going absolutely crazy right now, with a few specific influences going on there. They're expected to continue to climb as U.S. halts Russian gas Russian gas purchases of petroleum products. So that is going to be a very large factor in the short term of what we're seeing with regard to gas prices. Gas prices now hitting highs that were previously set in 2008. So looking back 14 years ago for the last time gas prices set a record. So it is certainly something to look at. We're seeing gas prices hitting an average of almost $4 a gallon right now. And in some cases, such as places in California, we're seeing those prices per gallon reach upwards of around $7 as of the recording of this podcast. So incredibly I wouldn't say alarming, but definitely of concern, especially with the high amounts of inflation that we've been seeing in the past months and roughly year, largely due to the issues caused by the COVID-19 pandemic, and also looking into the higher degrees of consumer price indexing that we're seeing as well. Another big issue coming in right now with the raw material commodity of wheat, but kind of ironically enough, coming into play with regard to exports and purchases, mainly in the Eastern European realm. But wheat commodities are soaring and due to export shutdowns. So another thing to look at with gas and wheat just going absolutely crazy right now. Gold also seeing a very high price point. It is trading at an 18-month high currently at almost at or above the recording of this podcast of $2,000 per troy ounce. So definitely something interesting to look at with regard to what has always typically been seen as a hedge against inflation, looking at precious metals, specifically gold, taking a very large ride up on the situations happening internationally right now. Another interesting commodity to look at, nickel commodities, mainly due to the fact that Russia being a large exporter of this particular commodity, looking at the commodities for nickel are just going absolutely nuts. Trading had to be shut down yesterday on 3/7 due to pricing and volume being outside the metrics for the particular commodities markets that we're exchanging in the U.S. So a lot of things to look at. Definitely some concerning things on the short term with regard to the markets going on right now, but it definitely is something that would hopefully make investors look at maybe more of a long-term play, and also looking at assets that are outside the realm of things traded on a securities market. We always like to preach here at Advanta the power of utilizing the entire suite of investment opportunities you have, and things like tangible assets such as gold, precious metals, real estate definitely are going to be shining a little bit more right now with the high volatility of stocks and securities in general. So if that's something of interest to you, definitely something to take a look at right now if you're trying to maybe rebalance or readjust your portfolio holdings to a more of a long-term play. And now it wouldn't be complete on the download if we didn't at least touch on a little bit of tech news. We have big news coming out of Google buying cybersecurity firm, and I apologize if I get this wrong, Mandiant, for an all-cash $5.4 billion deal. So continuing the trend of large IP purchases in the tech industry, although this may be not so much of an IP purchase as it is a physical company, but large acquisitions, let's say, in the technology realm. So again, Google buying a cybersecurity firm, Mandiant, again, trying to get more involved in the security aspect portion of the service suite that Google offers with all the other things that they have. So definitely interesting to see there that they are taking a bigger step in acquiring more property for security purposes for their customers and everyone in general. This has been The Download. Thanks for joining. Today on the what is beta? With how volatile markets have been recently, it is always good to understand what are some of the measurements of volatility in the market. And beta is a measurement of volatility or a systematic risk of a security or portfolio compared to the market as a whole. Beta is used in capital asset pricing models, CAPM, which describes the relationship between systematic risk and expected return for assets, usually stocks. The capital asset pricing model is widely used as a method for pricing risky securities or for generating estimates of the returns of assets, considering both risk of those assets and the cost of capital. This has been The What Is. Hi, everyone. Welcome to another edition of the Alternative Investing Advantage podcast. My name is Alex Perny, and I am very pleased to have on as a guest again our good friend and attorney, John Hyre, who has worked with our clients and worked in the self-directed IRA space now for many years. He's been a great resource to people and a great legal mind in the areas of tax avoidance and utilizing qualified plans to invest in alternative real estate. So I want to welcome in John. Thanks for being with us today.
Glad to be here. And I think we're having a little hiccup with Puerto Rico internet. You probably had a delay right there.
Yeah, a little bit of a delay. Maybe give us just a touch about your background and how you came to be in the space of the very, very specialized area of dealing with qualified plans and tax law.
Okay, I'm back. Sorry, there was a hiccup with the internet there. I don't know if we want to edit that out.
Yeah, we can edit it. It's fine.
Go, if you would repeat, because it totally locked up on me. That's the bad part about Puerto Rico. We're in the process of fixing that.
Gotcha. Again, welcome to this edition of the Alternative Investing Advantage podcast. My name is Alex Perny. Today, we are very, very pleased to welcome our good friend, John Hyre, an attorney specializing in tax law and specifically issues having to do with self-directed IRAs and alternative investments. Thanks for being with us today, John.
Glad to be here. Look forward to going back and forth on a few things.
Absolutely. So maybe give us a little bit of a background on yourself of how you came to be in this uniquely specialized position of dealing with taxes and self-directed IRAs, because I know there's not a lot of people like you out there that specialize in this kind of stuff. So let's give a bit of background and then we'll jump into the topic at hand today.
Sure. I've been practicing law for about 27 years. First 7 were corporate, and then that didn't really work, especially if you ask the people I worked for. And got out on my own, did mostly real estate investors, was familiar with self-directed IRAs and later 401ks. But what really got me into it, right around 2009, a client came and said, my self-directed IRA is being audited. I want you to represent me. And I, having this unfortunate non-lawyer-like propensity towards honesty, said, well, I might not be the guy to do the audit because I've never dealt with self-directed IRAs in an audit. And he says, neither has anyone else I've ever met. You at least admit it, plus you're studied on the subject, so please represent me. It ended well for the client. I'm ashamed to say I only charged him like $5,000, and that included both the audit and tax court. And we got a prohibited transaction reduced from 150 grand to zero. So it was an experience seeing how things worked from the inside. And then ever since then, I've gotten a lot more involved because even that little bit of experience is far more than most people have got. So that's what really led me down the path. And then, I'll add as an aside, when certain types of people hate something, I instantly become interested. So without going political, there are some websites out there that are not, let's just say they're not into tax planning and don't like rich people. So the first thing I do is look at what they hate, and they really hate Roth IRAs. And so there has to be something wonderful about them.
No, there's plenty of wonderful stuff about Roth IRAs. I tell everyone, although you don't necessarily have to use one in order to invest in something, if you do have the ability to get into one, whether it be via a conversion event or whether you can start contributing to one, which, me being a younger person, well, just turned 33, but I've been doing this for about 10 years. When I started back when I was 23, all my friends getting out of college asked me, it's like, what should I do? And I said, start a Roth IRA, put money into it. That's, the first thing I would recommend, even though I'm not a financial advisor. These things are insanely powerful tools. So, yeah, it's definitely a cool perspective that you have on this kind of stuff. Now, today, I really wanted to kind of utilize our time together to focus on a topic that's gotten a lot more press recently, although not be it a great outcome for the individual that was the subject of the case, but things called checkbook control. People often like to just use the blanket term of checkbook control to refer to an IRA client utilizing some type of entity. The lion's share of the time they're utilizing an LLC. Sometimes you can use a trust or you can use a trust. But essentially the way it works is that an IRA client will direct the custodian to become the sole shareholder with their IRA, or in some cases, a multi-member partnership. So that way that the IRA client can have control of the checkbook in the case of an LLC and act as the manager. Now, John, I know you have spoken extensively on this topic about some of the issues and pitfalls. So let's kind of give at least the legal mind's overview of the generalities of this, and then we'll kind of dig into that new case that just came out and what that kind of means going forward for people.
Right. So checkbook LLCs, by definition, it's an LLC 100% owned by the retirement account. And I'm going to use that term loosely to mean HSAs, even though they're not strictly retirement accounts, Coverdales, IRAs, 401ks. It's usually 100% owned by the account. The account holder is typically the manager, and there are permutations and changes. What does that allow? Control directly by the account owner of the funds in the IRA. And this is, as we're going to see in this case, what the IRS really objected to, especially in the case of IRAs. So there are different use cases for it, some of them better than others. I think there's been a lot of propaganda with people trying to make a quick buck, and consequently some bad decisions made. They make sense for asset protection, for example. If you have an investment, let's say low income rentals, which is, by the way, what I primarily did into my 401ks and IRAs until recently, because now they're not cheap anymore. That's primarily what I did. I wanted a checkbook LLC for asset protection, and that's a legitimate reason. But sometimes you find that people just want it because, well, they want it. And there's not always a really good reason behind it. Let me give you an example. I had a client call me one time, money in hand, ready to go, $1,500, set up my checkbook LLC. And yes, I cost more than the norm. I also do a lot more than the norm. A lot of the outfits out there that are mills that set up checkbook LLCs do a terrible job on the setup. And the setup's all they do. They don't talk to you. They don't discuss. They don't talk about how to use it or not use it. But we had a lady call. She's a hard money lender. And she said, I want a checkbook LLC. And I said, well, before you give me $1,500, let's go on the clock by the hour so I can talk you out of it. She was kind of bemused. And so she said, all right, well, why? I said, well, there's no asset protection issue. People don't typically trip and fall on notes. She said, that's true. I said, do you need the money the same day? Because some people who bid at an auction, for example, need to be able to write a check that day. I get that. That's a good use case. I said, do you need that? I mean, you're the lender. Don't you dictate when the borrower needs the money, and shouldn't they let you know ahead of time? And she said, no, yeah, our custodian is pretty good and fast, and I can get the money in time. So that's not an issue. I said, well, why do you want it? Well, I just want direct control. And I said, you already have it. Why would you pay me extra to do this? The custodian's not really a hindrance to you. They're not costing you any money, and you're not really getting any asset protection. And so we ended up talking her out of paying me a bunch of money. Not all clients listen. Sometimes when I tell them don't pay the lawyer, they still pay the lawyer, but that's humans.
Yeah. And I've had some other kind of use cases. I had a client back when I was doing investments. I know my previous role with Advanta, she was looking to buy a condominium in a 55 plus community. The HOA also included a caveat for property management and light things like that. And she had, a pretty lax closing schedule, and she wanted to use checkbook control for it. And, albeit there might be some aspects of, liability protections that can be gained in there. 55 plus communities typically aren't, in the norm of what you would see as maybe a high risk category of, tenants. And, we ended up just doing the investment directly through the IRA. She didn't have to pay, an annual registration to the state, didn't also have to pay an attorney to draft an operating agreement. So, and just like you said, in all use cases, these aren't kind of a panacea for any and all issues. If you have a good custodian that can write a check, quickly and doesn't take, a week and a day like some people out there, it's not necessarily for everyone. But like you said, with auctions, maybe for liability protections, or maybe if you're doing something where you're going to own a lot of assets, or maybe have stuff like a really intensive rehab project, they do work. Now, before we kind of get into the nuts and bolts of maybe some more of what we had talked about, one thing that comes up a lot is obviously asset protection. Now, this varies a lot from state to state. I know at least here in Florida, LLCs that have a single member are treated normally as a pass-through. They don't necessarily offer the suite of liability protections on, for liability, getting sued and stuff like a multi-member partnership would. So is the LLC kind of something that you need to look at from a state by state representation as far as liability protections go, or do even states that treat single member LLCs as a pass-through, do limited liability companies still offer a modicum of liability protections in those cases?
It does depend, not just state by state, but person by person. So Florida does protect single member LLCs from piercing from the inside. In other words, if there's a trip and fall on the rental property, the fact that it's a single member LLC technically doesn't matter. Now, as a practical matter, a lot of single member LLC owners do not properly maintain their LLC because their lawyer doesn't know how. And if they do know, they don't teach them how to do it. So Florida will protect from the inside out. In other words, actions by others, because LLCs normally won't protect you against yourself, but actions by others in the context of the LLC are protected in Florida if you have a properly maintained, and that's the key, and where I would say 80%, frankly, of entrepreneurs fall down, they don't maintain them right. So there is protection. Now, where there is not protection in Florida, the other way around, if the IRA has a creditor and owns the LLC, in most states, a single member LLC has some protection under what's called a charging order from when the IRA's owner, or I should say the LLC's owner, has a liability and someone now wants to go after the LLC to seize assets. In that regard, Florida says there's no good policy reason to provide protection, because the idea of the charging order is we don't want innocents to be harmed. If there's a 15-member LLC, one person has a creditor, the idea of keeping creditors from going after assets is because you don't want to harm the other members or the employees or whatever. Here, where it's just a single member, the policy reason is not really very strong. And Florida has made a decision to say, if you're a single member LLC and we're attacking it from the outside in other words, the owner has a liability, then we're going to go ahead and permit what's usually referred to as reverse piercing. So it depends on the situation, depends a lot on the individual. I've had some individuals that I've advised not to bother because I knew they just would not maintain the entity properly and it was pointless.
Yeah, great point. It's something I always like to bring up to people is that, just having an LLC, just because you have it doesn't necessarily mean that it's going to do what you need to do. It's kind of like, owning a car and never changing the oil. It's like, yeah, it may run, just fine, but the second you have one issue, there's going to be a lot of cascading things because, you never did the appropriate things to maintain that to, have all the protections that you need, not changing brakes, tires, and everything's like that. Second the road gets wet, you start skidding out. Just because you had it doesn't mean it's going to protect you. So let's kind of jump into what we kind of wanted to have you on here. There's been some recent updates to at least some case law that's come out recently. And to preface this before we get into that part, in general context, there are rules regarding IRA transactions. And just like with anything with financial instruments, there are, a set of rules. It's not just the Wild West, you have to follow some specific rules. And with IRAs, there's a clear delineation of the IRS stating that the IRA owner can't act in a service capacity to the IRA, and they also can't have direct control over an IRA-owned asset. Now, that is a huge gray area because we have things like a brokerage account. If you have an account with Fidelity, you can kind of act in the broker capacity. You log on to your account, you have $10,000 in an IRA, you can buy, sell, and trade stocks to your heart content without having, to put an order to a broker in. You can create option contracts. I sincerely hope that any brokerage house won't allow margin activities to an IRA, but I know for a fact that they do because they don't correctly modify their APIs to comply with IRS rules. So that's a whole other kind of conversation for another day. But there are strict controls in there. So far, like with what we do with IRAs, if an IRA owner buys a house with an IRA, they can't go out and replace the water heater themselves. They can't go out and perform a direct service or improve or benefit from their IRA-owned property. Now, this case that came up is going to center around things as far as direct control and constructive receipt, which I'll let John get into what the actual legal definitions of those things are, with a client having a checkbook control IRA, so an IRA owning an LLC, and then owning precious metals. Now, precious metals, especially in periods of high inflation like we're going through right now, 7% increases into the CPI index, what's going on over in Eastern Europe right now, have a huge driving factor towards people wanting to invest in assets that can be seen as a hedge on inflation. And this is kind of a good, warning, or maybe slightly a canary in a coal mine for people to, act right and run their IRAs accordingly. So, John, I'll let you kind of jump in to, what this case is, what this case isn't, and we'll go from there.
All right. So the name of the case is McNulty. And what had happened is that Mrs. McNulty created a Checkbook LLC. So she put the IRA money into it. She was the manager. It was clearly a cheapy one where she just set it up and was allowed to do whatever she wanted. She didn't have very much training, which is very typical, right? When you get these $500, hey, we'll set up your Checkbook LLC. Those guys usually don't know what they're doing, not for that kind of money. It's just the case. The IRS, and for that matter, me, have been against buying gold in your IRA and taking physical possession of it. I think that was doomed for failure from day one. Again, in spite of a lot of promoters saying otherwise. So Mrs. McNulty basically took control of her IRA's money through an LLC. The IRA owned 100%. She was the manager. She ordered physical gold. She had it delivered under various names. She paid for it with the IRA money. Now, gold is hard to title, which is what makes this case interesting. There were no certificates. There was no proof of ownership. It's not like there was a brand in the gold that said owned by my IRA. She received it at her personal residence and put it in a safe right next to all the other gold she owned personally. That's the basics. And this was a slam dunk case. You got to understand that the tax court, when the IRS gets sued in tax court, 95% of those cases settle. The IRS only goes after the 5% that they think are a slam dunk. And in this case, they thought correctly that they had the slam dunk. So we've got two reactions to the case, because what the court said was, listen, you took physical possession of the gold. Taking physical possession or constructive possession, we're going to talk about that idea here in a minute because it's important. Taking physical possession of an asset, it's just fatal. The whole idea of IRAs is there's a custodian, they have possession of the assets, and you direct them what to do. But if you choose to take possession of the asset, then you have a distribution. So the court said your IRA, it was entirely invested in gold in her case, is distributed. We are taxing the distribution, we're penalizing you, and they penalized the heck out of her. They said, we're adding a 20% essentially negligence penalty because you should have known this was not kosher. You did not do any reasonable research. You did not give your accountant all the facts. You just read a promotional website on the internet that said you can do this. And the court said reading promotional websites on the internet doesn't count as research because the promoters are going to promote. That's not legal advice. It's not legitimate research. So her IRA died. She paid a bunch of penalties on the distribution. And there have been two extreme reactions and then some more nuanced reactions. And I want to get into the nuance in a minute.
Yeah,
go ahead.
Just to one point on that, and you know, in being a business, you know, we have to make sure that you know, we don't come off as inflammatory towards other people. But one of my biggest pet peeves of being an IRA professional for you know, 10 years now is this whole concept of when we have these people that are IRA custodians, or maybe they're just a marketing tool of some other people that advertise this whole, you know, use the Checkbook IRA LLC to take physical possession of the gold, is something that, you know, even when I talk to even our competitors that at least have, you know, a pretty good outfit, is one of the things that I just can never tell people and warn people enough about. You know, gold is, in a technical sense, what's called a bearer instrument. You know, if you ever watched you know, Die Hard, and they talk about bearer bonds, meaning that the person who actually has something in their hand, you know, is really the owner of it. There's no way to prove otherwise. It is, you know, you put a piece of gold in your hand, there's, like John said, there's no title to it. And part of the concept of using an IRA is that you have to have a delineation and some type of separation of a trust or custodial relationship to those assets to separate you from them to get all those great tax benefits. So the implication that you can take something that is essentially a no titled asset and a bearer instrument and put it in your own house's safe is something that I don't understand why the IRS just hasn't, you know, put out a circular publication telling these people to stop what they're doing and doing this kind of stuff, because it is just so dangerous. And I really hope some good comes out of this case. Obviously, I feel bad, you know, for the people that had this happen to them. You know, I never like seeing, you know, someone's retirement plan blown up like it did in the McNulty case. But you know, that's kind of my 2 cents on it, is that it is such a dangerous line to take that some of these people market this as a viable option, which is, you know, to say that it's bad faith marketing is, you know, about as mean as I can get to it, and something that we put out as a company. But I'll let you kind of go into it. But that's my 2 cents on it, just how dangerous that kind of line of thinking can be.
So the Checkbook, the company that set up the Checkbook LLC has not modified their website since this case came out. I mean, they're named in the case, and they're still selling Checkbook LLCs as if nothing had happened. Now, I'm sure they no longer allow it for gold, so maybe they made that change. But in terms of the overall Checkbook LLC concept, they're pretending nothing happened. And what they're really doing is just selling templates, and not very good ones, in my opinion, of a Checkbook LLC operating agreement that is custom made for you to the extent that your name of the company is different and the members are different and the address is different, but it's otherwise boilerplate that they're just selling at, you know, $500 a pop. They're not even lawyers. They're not even freaking lawyers, but everybody wants to quote unquote save money. And so they went to them instead of to someone who knows what they're doing. And this is what happens. The problem is it creates uncertainty for everyone else. And that's kind of like what I'd like to dig into. How do we react to this? I mean, there are two extremes. Extreme number one, this only applies to Checkbook LLCs that hold gold. It applies to nothing else. And that's sort of kind of technically true, but not really the whole truth. Because of some of the language in the case that we're going to discuss, they have now created a launch pad for new IRS attacks on Checkbook LLCs. And I think we have to be mindful of that. So someone is just saying, well, this only applies to LLCs that hold gold. They probably have an agenda, and their agenda is they want to keep selling Checkbook LLCs. And so they want to just close their eyes and pretend this didn't happen. Second, the other side of it, Checkbook LLCs are completely banned They are utterly illegal. There's one guy in particular whose name I won't mention. He's a well-known promoter of 401ks, and he's a lot better at promoting than, say, giving really good advice.
I know who you're talking about.
And he's jumping up and down screaming, checkbook LLCs are illegal. You need to roll your traditional accounts into a 401k. Now, he has a point. He's full of it. And he also has a point. He has a point in that this case has less effect. I wouldn't say zero effect, but far less effect on 401ks, whether it's a solo K, a normal 401k, a safe harbor 401k. 401ks, unlike IRAs, do not require a custodian. You are allowed to be the custodian, AKA the trustee. Now, should you be is a different question, right? You have to be good at admin and able to follow instructions and so forth. So the fact that you can be the trustee of your 401k doesn't mean you should be. But trustees are understood to have possession of assets on behalf of the trust. So 401ks are not completely immune from the McNulty case. I would say they've got major immunity. Certainly, boy, I hate to use the term, a vaccine, just because of how they're set up. And that'll trigger a few people. You'll get a few emails about that use of that word, but oh well. So those are the extremes. Here's where we have some gray. The IRS and the tax court said you are not allowed to have constructive possession of assets. You are allowed, you are permitted to act as a conduit for the IRA, which we're going to discuss, but you're not allowed to have constructive possession of the assets. The problem is the case law here is not really well developed. What is constructive possession? I'm going to give you a couple of examples. Take a breath, let you interrupt, because you know how it is. That's the only way to get a word in.
Yeah, exactly. Yeah, and there's another case, if we have time, that I want to kind of go through that I think will, or it's a tax court memo, the TC Ellis in 2013, that I think kind of would be a good kind of adjunct to this if you're familiar with that one as well, once we get through some more of the details of this. Are you familiar with that one?
Yeah, oh yeah.
Yeah.
So let's remember what the court said. They said, if you have constructive receipt, we're going to define that in a minute as best we can. If you have constructive receipt of an asset, for the IRA, it's considered distributed. What does constructive receipt mean? The court defined it to mean complete unfettered control over the asset, which Mrs. McNulty clearly had, complete unfettered control over the gold coins. So she didn't do anything wrong with the coins. She didn't use the coins, for example, for her own personal benefit, which would have been a prohibited transaction. We're not talking about prohibited transactions. We're talking that if you have complete unfettered control, whatever that means, over any asset of the IRA, that asset is deemed distributed. And let me give you two examples, and then we can go into some back and forth on hypotheticals. We do have a little bit of case law. One of the cases cited here was Ansira. What happened in the Ansira case? The IRA owner got a hold of stock shares, so the physical paper shares that the IRA owned in a company. And the IRS argued, you have physical possession of the stock shares, so they should be distributed. And the tax court said, no. The taxpayer had physical possession, but not constructive possession. In other words, they did not have complete unfettered control. Why? Well, the stock shares were titled to the IRA, and the taxpayer could not have converted them to cash had the taxpayer even wished to do it. And so the court said, it's weird that they had the physical possession, but there were some reasons for it. And then they moved the shares to where they belong in the physical possession of the custodian. And it ended up okay. So that's a good example of when you don't have constructive receipt. Another example in the case law, a taxpayer receiving a check on behalf of the IRA, but the check was written to the IRA, not to the taxpayer. And therefore, the physical possession was not a problem. The taxpayer was acting as a conduit to the custodian. They sent the check to the custodian deposited it in the bank account. They did not have complete unfettered control over the check. And what was important in that case is that under state law, a check written to the IRA was not negotiable, meaning it couldn't be cashed by the taxpayer. That was a very key point. And so there's the difference between physical and constructive receipt. We want to avoid constructive receipt. And to give you a primer, Alex, of where I want to go, but I'll create a space for you to interrupt so you don't have to do it on your own. I want to talk about, in particular, a bank account that the taxpayer would have control over if they're the sole manager of an LLC. You have a rental property, and we can title it properly, and there are things we can do to reduce your direct control over it. But what about that bank account? Could you, if you wanted to, remove the money physically anytime you want, even if you choose not to do so? Could you? And then second, a big one, cold storage for crypto. Would that be similar to gold in the basement? That's where I'd like to go.
Yeah, exactly. And I think, and the crypto one's definitely a little bit more of a departure. And I think that we might actually probably agree a little bit more on that, on some of the potential issues and things like that. But as far as constructive versus physical receipt, when I see, and I kind of drew a parallel between this earlier, is that, a lot of times, back in, let's say, the early 90s, back into the 50s, if you wanted to buy a stock, and, IRAs have been around since the 70s, so let's demarcate it in the 70s. So let's say 75 to probably about 95, when the internet starts becoming a thing. If you wanted to place a trade in your IRA, you had to call, John or Jane broker and say, hey, I'd like to buy some Sears, or I want to buy, ExxonMobil or something. And they place that trade. You don't have any direct access to that account per se. You had, a clear intermediary with that. Now with, let's say, your E-Trades and your Fidelities and your TD Ameritrades, there isn't that kind of, intermediary. And just like with an LLC's bank account, you log on to your, bank account website and you can have a check issued here. You can control all the aspects of that, just like you can with an IRA brokerage, and say, hey, buy, sell, trade X, Y, and Z. Granted, the constructive receipt issue not being so much, or the constructive or physical receipt issue not being so much, because everything's held in book entry. You're not worrying about getting a paper share or anything, but you do kind of have that unfettered access to an account that is supposed to be held in custody or in trust, that you can direct everything to, make all those actions, buy, sell, and trade, and perform all of those things in a very similar fashion to having a checkbook control LLC. Now, what people see a lot of difference in is that, when you deal with tangible or non-traditional alternative assets, it's a lot more paperwork intensive. Things like titles to or deeds to houses, or mortgaged notes, or different type of instruments, things like checks, as you mentioned, things that, hopefully are being issued in a non-negotiable fashion. So if you put your hand on it, it's not an issue. Those kind of things do kind of crop up. But I always, when people ask me that question, I always point them to kind of the brokerage account issue when it comes to most of the issues that people have questions about on the LLC side. Is that, well, if this is a relatively understood, accepted practice, so long as that you understand the IRS rules and are good at bookkeeping, like you said. I always say that, I'm like, if you can balance your own checkbook, and if you've ever run a business and know how to run QuickBooks, you can probably be successful if you follow all the other rules with LLCs in doing checkbook control, with your account. Now, whether should you, for your asset class and everything else you're doing, that's a question between you, yourself, and God of should you be doing it? But that's kind of my take on it, is that, you have a relatively accepted practice that has evolved over at least the past, 20, 25 years of the brokerage side of things. And I see a lot of parallels with the checkbook control. And I use that term loosely, because obviously that can have a lot of different meanings, but that's kind of, my 2 cents on at least that aspect of it, and how things should work in similarities in other industries.
So let's cover for a minute bank account control, because now the door is open.
Yeah.
The door is open for the IRS to attack any checkbook LLC where the IRA owner is the manager, or someone who's just their cat's paw, who's just, an extension of them that has no true independence. The door is open for the IRS to start arguing, well, what is constructive receipt? One of my concerns is, and people will say I'm paranoid. Well, that's my job. I read the law. Even if the IRS hasn't applied the law in a certain way, I try to think, if I were an IRS lawyer, how would I use this to nail you? And people said we were paranoid about checkbook LLCs until we weren't. So if you have the ability, you have control over the LLC bank account, you have the ability to write a check or make a wire happen or whatnot, you could send it to yourself. Mm-hmm. Now, the fact that you don't is irrelevant, because what the IRS looked at was you have this power. So the question is, if you have access and signing power and withdrawal power to the LLC bank account, could you be considered to have constructive receipt? I can't answer the question, do you have constructive receipt? There's no case law. Could you have constructive receipt? I think you could. Now, some people will say that's paranoid. And again, I'm like, okay, maybe it will be. And then again, until it isn't. So what's a solution? And here's the problem. There's always a trade-off. The way we've been helping clients, first, what you first discussed on the call, we discussed, look, is it worth the hassle? Are you getting enough benefit from the Checkbook LLC that you want to deal with paying me? Because the $500 online guy isn't going to be this nuanced, and he doesn't know what he's doing. His template doesn't cover this. So the two solutions we present once we decide it's worth even thinking about that is A, co-managers. You're the operations manager, and we still caution them as to operationally, what should you do, what shouldn't you do, because we have the issue of you're not allowed to provide a service. That's not, you don't know what that means. So you're not allowed to provide a service. So we caution them on that, and we word the operating agreement and customize it, by the way. So for example, we will make the operating agreement talk about exactly what people can and can't do, including the manager. And so bank account, and they are the only ones that have access. You have viewing rights, so you can tell if they're up to something, but the financial co-manager has to sign all checks, and they really do. I mean, if you just have a rubber stamp with their name, that the IRS will look through that. Oh, how will they ever know? Well, they'll ask you a question, are you willing to perjure yourself? So one solution is a co-manager who has control over the bank account, and you have pretty much operational control. It is to put the other person completely in charge. They have operational control, which gets us around service issues on prohibited transactions, as well as this possibility of constructive receipt on the bank account. But the problem is what? That's a custom-made agreement. It's going to cost more money, and you're trading off risks. Now you're safer from the IRS, but you got to pay me or someone like me that knows what they're doing. And second, you got another human being involved, and that human being may not show up on time, may not do things right, probably wants paid, et cetera, et cetera. So now it's really a case of choose your poison. What do you think?
No, I think you're really onto something with that. And you know, from the service aspect, at least me personally, I diverge in saying, you know, I don't think it's necessarily a service. I always, you know, to sound like a broken record, go back to the brokerage thing. You know, you can execute sale orders, option contracts and things directly as the IRA, and there's really not much of an issue with that. The constructive receipt thing, I do really think is the next thing that'll need to be looked at by the IRS in more detail on that front, because that really is the issue, is that, you know, if you have someone, you know, signing something and then receiving in like a receipt of, let's say, you know, a deed to a property, or in this case, you know, I think precious metals within an IRA owned LLC, if you're doing anything other than using a clear third party storage facility like Delaware Depository or First State Depository, or someone local to you that does stuff for IRA custodians and is familiar with that process, is just you're tickling the dragon's tail with that. You know, it's eventually going to wake up. It's going to bite you, just like it did in this case. I don't think there's really any type of safe guidance I could give anyone on doing precious metals with an LLC. And, you know, to kind of, not to have a shameless plug, but if you just want precious metals in an IRA our fees are so cheap for doing that. It's, you know, you're to pay for the LLC and everything like that, you're probably going to be, you know, 6 years worth of our fees just to have done it in the IRA directly, and then not even have to worry about this stuff at night. So I think it's a great point to make. And also, you know, from that aspect of bifurcating the management stuff, you know, I think people, you know, really look at the LLC. It's like, oh, well, I didn't want to use the trust because I can't act as the fiduciary to my IRA. Therefore, I can't be a trustee, is why I use the LLC. And then they're going to say, well, this kind of gets, away from that. Well, if you don't want to have the issue like these people did, where not only are you having this deemed as a taxable distribution, but you're having the IRS, paint a bullseye and shoot you with a 20%, penalty as well, then, what's the trade-off? Is a little bit of a headache. Or what is it? It's an ounce of prevention is worth a pound of cure. It's, what are you trying to accomplish with this? And when you're talking about retirement nest eggs, a little bit of hassle can really be great when you don't have to rely on, a social security check to supplement your retirement plan that you lost in your future. So I kind of agree with you on that, is that, there's always going to be, good, better, best, and that. And unfortunately, there's nothing perfect, because just like with case law, stuff changes, stuff that was acceptable, way back when is not, look at marijuana is an easy one. It's like super illegal in 1980. Now we have like 30 states where it's not. So, laws change, and you have to always kind of try to, keep up with those changes, and, try to be one step ahead, so you're not, 2 steps behind when something changes.
Yeah, I hear you. It's constantly changing. Look, if you look at the net present value of IRAs, especially Roths, but also traditionals, likewise with 401ks, which I know you guys offer. And again, I think 401ks are somewhat less susceptible to the problems this case brought up. There are huge benefits, net present value wise. The benefits are huge, but there's a price. There's always a trade-off. There's always a cost. And the cost just went up because of this case. Checkbook LLCs, and by the way, I include trusts in that. Some people have magical trust schemes that are, quote unquote, different from LLCs. Not really.
I don't like
it. It's the same issue.
Yeah.
If you substitute trustee and trust for manager and LLC, you would have exactly the same issue. I think my other big concern is cold storage owned by an IRA physically in the possession of the IRA owner. I think that's one where you really want to have a third person have that possession. Boy, have you better trust them. Or don't go for cold storage in your IRA. Just like gold, my advice to people is, listen, IRAs are great for income producing assets. If you want something to have your hands on during the apocalypse, don't put it in your IRA. That should be personally owned.
Yeah.
Crypto, and I get the arguments. I've talked to, I'm in Puerto Rico, so I'm surrounded by just hordes of crypto bros, some who really know what they're doing and some not so much. And we have the discussions, and they're like, look, the cold storage is just a password. It's not actually possession of the asset. And I explain, we don't have to have, you're too focused on physical possession, which naturally makes you think there is constructive possession. But if the key is what you physically have, and you could access and transfer those assets to yourself if you wanted to, in other words, complete and unfettered control, which with a rental, for example, the title to the rental is in the LLC that the IRA owns. So if you don't have the ability to sign that title over to yourself, that's going to depend on how the LLC operating agreement's drafted. Then you don't have the ability to move that asset. I think the rental property is much less vulnerable, just like a stock certificate, to a constructive receipt argument, where crypto cold storage and maybe even some forms of hot storage look to me more susceptible to being looked at like gold. And I think rightly or wrongly, the IRS might view physically holding the cold storage similar to physically holding the gold, even though I understand that the cold storage is just a password and the actual quote unquote value, at least in theory, resides elsewhere. I understand the argument. I just think that people that are doing this need to understand the counter argument. I would strongly consider doing that in a 401k outside of an IRA, or perhaps not using the cold storage, because I think the online storage, whether it's hot storage or whether you're on an account, whether you're on one of the exchanges, I think it's a lot less susceptible to one of these arguments. Certainly the perception is less that it's physically possessed, which shouldn't matter but does. But of course there are trade-offs too, right? I mean, we look at some recent hacking that's occurred with regard to stuff that's on exchanges, and there's always trade-offs. Of course, the trade-off with the cold storage is like all these famous cases, you better not lose the freaking password.
Yeah, exactly. And what I've told people in the past with this is that, I know enough to be dangerous with cryptocurrency. I find it fascinating. I don't always practice with equity. I don't invest in it as much as I know about it. And maybe I should, since I do know quite a bit about it. But what I always tell people with that stuff is that, yes, this kind of case brings up a lot of issues, but is that to use an example, the nano ledger, which is a very popular cold storage option, is that, yeah, you can set up multiple accounts and sign-ins on it, and you can, bifurcate the accounts on it. But what I tell people is that if you're going to do this, absolutely don't do that. If you have personal stuff on it, don't do it. Buy it directly with LLC funds, have a receipt that has the LLC sending money to this to purchase that direct piece of hardware, and only ever put LLC assets on it. Never use that address for anything else other than your LLC, to make sure that you have clear delineation between and segregation between anything you own personally and that. So that way, if the IRS comes knocking, you can say, hey, not only did I just, I didn't just have this lying around from something else personally. You say, hey, I have a receipt where the LLC specific to this use case purchased this. Everything else with my transactions going into this piece of hardware is only for IRA owned assets. And, then you can say, hey, and to get a little technical, yes, it is passwords that are stored. All of these transactions really are more in the ether of the blockchain. So, you have a separation from the actual physical assets being, more the public domain on the blockchain. But what I will kind of go back to, and there's a lot of different cases out there, that kind of illustrate this next point I'm going to make, is that for most people need to understand, people that are fresh out of law school, they're 24, 25, even in their 30s. These people are not judges. These people are not especially tax court judges, which, at least in tax court where this stuff resides, it's not necessarily a jury by trial most of the time. You're sitting in front of a judge and an attorney from the district of the tax court that you're in. And if you've ever tried to explain technology to, let's say, your parents or your grandparents, you never want to be in that situation where you're having to explain the nuanced difference of saying, oh, well, you purchased this asset and it's actually in public domain and it's never actually physically here. I'm just basically utilizing a piece of hardware that stores securely passwords so that way I can interface with this huge public domain that is able to exchange assets across nations and users. That is not a position you want to be in. My grandfather, I love him to death. And he's actually remarkably savvy for being 89-year-olds with his iPhone. I tried to explain cryptocurrency to them the other day, and his reaction when I was done with him said, do you want some more greens and a biscuit? Those are the people, obviously 89-year-old people typically don't sit on the bench, but you don't want to be in the position where you're the guinea pig trying to explain the nuances of cryptocurrency and qualified plan investing to a tax court judge and an IRS attorney.
Totally. I was chuckling over that one. It's so true. I mean, here's the honest question you have to ask, and you have to be honest with you. If you can't be honest with you, you're going to have a really hard time being honest with others. You have to honestly ask yourself, whatever form you're holding the crypto in for your IRA, do you have complete unfettered control? Are you able to treat it as if it were gold? Is it more like the gold? Or is it more like a house or more like a check or stock certificate that is titled in the name of the IRA and therefore would be very difficult for you to get in your name? I think that's going to be the question that's going to be asked, and that's the question that's going to be litigated. I think people need to be aware of the issue and make a decision. Some of them are saying, you know what, we don't want to pay, we'll take the risk. We're going to keep plodding right along the way we have until the IRS attacks something that's not gold. And some other people are very, well, there's a statute of limitations. I want to think ahead. And there's enough value in my Checkbook LLC that I want to protect it. And I am willing to go through the hassle of having a co-manager and a custom operating agreement to minimize the risk that this will happen to me. And so it's a subjective choice. That's the problem here, is we're dealing with a ton of gray. I totally get that. I do not. I mean, some of the crypto bros got a little, you know how they can be, a little full of themselves, especially whenever like BTC is up, they're reveling in the streets and they're very sure of themselves. And crypto bros, I love you, but you know this is true, right? So, and they're like, well, this is how the technology works and you clearly don't understand it. So let me explain it to you as if you were a first grader. Good luck taking that approach with a 50-year-old tax judge.
Mm-hmm. Yeah, exactly. And that's the thing, is that I feel 100% confident. Granted, I am not an attorney, but if I were to sit in tax court, I feel confident that I could explain something that would resonate with almost anyone. But and there are people like me, and then you have to have, if you want to be put in that situation, you have to understand it. You have to make sure your attorney understands it, and then you have to hope that the judge is going to understand it. So you have to be willing to accept that risk of three layers of comprehension to the point that you're trying to make. And correct me if I'm wrong, but the burden of innocence and guilt is a little bit different in tax court, correct? They're not under the burden of proving guilt. You're under the burden of proving your innocence in tax court. Is that correct?
That's essentially right. You have to prove what you did was right. The burden of proof is rarely on the IRS. If there's a tie, they're right, you're wrong.
Yeah. So not only is this not what you're used to on, like, watching your TV shows and stuff, like tax court's a whole different animal, and it's not only can be criminal issues, there can be huge financial ones too. So it's, the crypto stuff's interesting. I want to continue to watch it, and I hope that this tax case brings up some best practices for people, because the last thing I ever want to see a client do is get hammered by the IRS or lose anything that they've worked so hard for. But at the same time, clients have a propensity to kind of do what they want and want to take a path of least resistance. And I think this is really great information for people to understand that, to re-examine this stuff, at least when new information comes out, because that's all we can do is do things that are accepted. And then when new information comes out, adjust accordingly. And I think this really brings up some good points. Now, to kind of, bring this into a culmination, is that what are, I don't know if you have current figures on this, but do you know what the locus of the case of how this was brought about? Like, was there an audit that extended into their personal finances, or how did this thing actually get triggered and start this whole avalanche of mess for these people?
I'll know more soon. My understanding right now is that it was just a random audit, and the IRS learned of the gold in the IRA and started digging into it. So it was not, from what I understand, a specifically IRA, because I've seen audits of IRAs that are IRA driven. Here, they kind of back-ended their way into it. Now, it's funny you ask, something I do that most tax lawyers don't. The case decision is what you get, right? When we look up the McNulty case, what you just get is the decision. But there's a shopping cart full of materials that you used to have to access until very recently by flying to the tax court DC, sitting in a little room, and they'd bring out literally the shopping cart full of the IRS briefs, the taxpayer briefs, the cross-examination of all the witnesses, including the taxpayers' returns minus their social security number, just this huge amount of information that's super informative that most people don't take the time to dig into. Well, this morning I got an email with the relevant attachments, some of the stuff that I just named, because the IRS is finally, it appears, going online with that kind of stuff. So I should have more information on how this case developed, what arguments were winners and losers, because there are going to be a bunch of arguments that were made. And we need to know about these arguments, because even if they weren't brought up in this case, they're kind of fallback arguments for the IRS. But my understanding is the audit was just random and then got into the IRA, and not that it started with the IRA.
Okay. Yeah, because I think that's a really good point that you make, is because, ultimately we know the decision. So we know that ultimately what they were arguing didn't work, which can kind of, better shape and policy is kind of a bad word for maybe the practice of IRA clients trying to do this stuff. Because if you know that, obviously every tax court judge is different, but there's probably a prevailing sentiment among most of them of how these things play out. This case may not have gone the same way with a different judge, but it definitely is going to give us a good insight into what they were trying to say was the case and what they didn't think held water. So I'd be very interested to know what comes of that. If once you get through that, maybe we can reconvene, or if there's any information you want to send over, we're always happy to publish more good details for our clients to read.
Oh, this is going to be such a time suck for me because now it allows me to access so many cases that I want to see the guts of because it's so informative. Because when I advise clients put together info product, I am thinking about the IRS's litigating position and how their lawyers think and how my client can be one of the 19 that the tax court case gets settled, usually on very good terms for the taxpayer, and they're not the ones that end up going to trial. That's one of my goals. Now, as a professional, there are other requirements, so that's just one of them. But I love being able to dig inside of these cases and see what really happened.
Yeah, absolutely. I mean, that's what we really, really need to know ultimately is that, it's great knowing that, someone's guilty and what happened because of, quote, what they did. Because again, we just get the complaint of saying, hey, here's what happened and here's what the tax court did. So I think it's very important for that. But to kind of come back to another thing I think that you mentioned was interesting on the 401k side of things, and yes, I am familiar with the pontification of some people out there on how curative it is to just have this 401k and X, Y, and Z. What I really try to tell people is that, and when this came out, and obviously it's pretty recent, is that people are like, oh, I need to do a 401k. What can I do? How do I qualify? Because it's this is going to solve all these problems. Is that when the IRS starts digging into these things, it's not just saying, oh, we're only going to look, this was a traditional IRA, no need to look anywhere else. This is that first kind of pry into retirement plans in general. And albeit the fact that 401ks have the added benefit of being legislated also by the Department of Labor, so their rules are a little bit different and more robust in some cases. It kind of opens that up to saying, hey, 401ks, and we saw this with a great example is with all the really, there's not a nice way of putting it. Let's just say not friendly legislation proposals that came out last year with regard to changing a whole bunch of rules with types of assets and things that you and our company as well lobbied against. Because they start poking into IRAs, this stuff is going to spread. It is, a virus that is going to start in one place and is going to multiply into others. And it's important to understand that best practices taken now, if they examine this in other people and see that, okay, this wasn't an issue, can greatly help the ecosystem as a whole of people wanting to invest in these kind of things.
Yeah, I think the 401ks are less vulnerable, just given the nature of the case and how it was written. That doesn't mean invulnerable. I think if you're the trustee of a 401k, again, you have to be good at being a trustee, which means keeping the trust assets, the 401k, separate from everything else. So I still think the principle applies, even though the account is less vulnerable when compared to an IRA.
Yeah, and what I really think on the gold part is just the fact that it is a untitled bearer instrument. It's kind of like just having a block of cash. There's nothing that says that, this serial number is not tied to Alex Perny. It's, I'm holding it, it's mine. I stole it unless someone has a track, serial number on it, then it's like, okay, well, how do you prove that it wasn't? So I even think with the 401ks, with physical metals like this, either having, a local bank account or safe to storage box that's billed to the 401k, or even just using one of the big, storage facilities. Granted, I know for precious metal clients are big on the whole, like, tangible, super readily available asset. Gold has been used in trade since the Mesopotamians, that kind of whole aspect of their thinking on it, hey, I want to have physical possession of it. But I just really feel personally that taking physical possession, even if you're a trustee, is dangerous to say the least.
I would not take physical possession in a 401k. I think the same rules apply in terms of having to have it in a depository. I'm very, very much against that. If you want to have gold for the apocalypse, buy it with your personal money. And if your argument is, I don't have personal money, all my money's in my 401k, I'm buying the gold so that if there is an apocalypse, I can run away with the gold. You're using the account for your personal benefit. That's a whole separate issue you don't want to do or get into. Bottom line is, if you can't handle having the gold in the depository, I don't think you should be holding it in a retirement account. And I think this case made that really, really clear.
Yeah, exactly. And also, if you're concerned about the apocalypse, I don't think you're probably going to be paying taxes in the apocalypse. So maybe that's something to think about. In that qualified plan might kind of be a moot point if everything's going to pot. So I've said that to a few people and I got a chuckle out of it. But I'm like, you know what? Like, if that's what you really want, doing it personally, yeah, it's something to think about. The IRAs aren't going to mean much if people are, going, full book of Eli and, everything's just kind of going Mad Max and Road Warrior.
And I get it with inflation and all. I mean, I'm a fan of various cryptocurrencies, the more stable ones, that being a relative term with crypto. But I think the overall trajectory is probably going to be up. Likewise with precious metals. So I'm not saying planning for the worst is a bad idea. I just don't think gold and maybe cold storage crypto are very good assets to be held, certainly in an IRA and not even in a 401k. I think the 401k is less vulnerable, except with the gold. I think the gold, part of the problem there is there's a specific code section on that. And the promoters have, I think, been distorting and misreading it on purpose to make their money. And the people who wanted to believe them because when someone tells me what I want to believe, it's just so much better.
Yeah, it's one of those things, especially with when it comes to finances. Someone telling you the only things that you want to hear and want to believe is dangerous. Always get second, third opinions with this kind of stuff. And if someone's telling you stuff and you don't like every single thing that you hear from them about it, that might be a good sign, because that means that they are, not only just trying to get a sale, they're trying to make sure that you are in a good position and having the information to make an informed decision as well. So I think that's a very good line to take.
This was very relevant in the tax court decision. The tax court penalized the McNaldy's an extra 20% on top of the taxes paid because it said you believed a promoter whose job was to sell. They wanted to sell, you wanted to buy, you wanted to believe. You needed to talk to your CPA and you didn't. You needed to tell your CPA all the facts and you didn't. So you were reckless, you were negligent, and we're going to penalize you for that. So you can't treat taxes the way everybody seems to want to treat politics nowadays, which is I only listen to that which I wish to hear.
Exactly. I think that's a phenomenal point. And we're kind of running up on the end of our time here. I really appreciate you taking time out of your busy day. I know you do a lot of different education. I think you have a closed group that you run as well and things like that. So if you want to give a plug to what you got going on, I don't know if you have any classes coming up either. I will say I've been in attendance to several of your classes, and they are extremely beneficial if you are looking to get some good insight from a good legal mind. Typically they're like 2 days long. And if you got any of those going on, I've been to a few. I can speak from experience. I definitely got a lot out of them. So I'll let you plug what you got going on and how people can get a hold of you.
Yeah, I won't go into the specific classes. We will have about 4 or 5 before the end of the year. I think right now we only have 1 posted. We tend to do them some in Puerto Rico, some online, and some in the US. So it's a good excuse to come to Puerto Rico. In fact, the way I normally structure the Puerto Rican ones are class on Friday, class on Monday, weekend off, but weekend still a deduction given how the code works. We tend to do classes on self-directed investing, and small business and real estate investing as well tends to be the focus. I do have a closed group. It's where you can ask questions because I only now work about 3 hours a day on billable stuff, and I go to pretty respectable rate. So a lot of people like to get into what I call the inner circle group, and we'll give you where to get that. We have 3 meetings a month, 1 advanced topic, 1 basic topic, and 1 that's pure open Q&A. And I answer about 90% of the questions. Now, some people get stupid and send in a 50-page book saying you have to answer this as part of my monthly subscription fee, and we just give them their money back and tell them to go away. So the websites are, and that just went out of my head, taxreductionclass.com, taxreductionclass.com, and taxreductionlawyer.com. taxreductionlawyer.com. So yeah, we'd love to hear from people if you think we can be of use.
Yeah, absolutely. Again, it's been great knowing you over the years, and I definitely got a lot of good information from our relationship. So again, everyone, we had John Hyre on today. This has been another edition of the Alternative Investing Advantage podcast. If you have any questions for me here at Advanta, you can reach me at 727-754-9954 or advantaira.com. And John just gave his 2 websites. You can get in touch with him. Again, thanks for very much for being a part of this Alternative Investing Advantage podcast today, John, and we will catch everyone on the next one. Thank you for tuning in to the Alternative Investing Advantage podcast. Tune in next week for more investing tips and strategies.
Want to hear more episodes of the Alternative Investing Advantage? Search podcast at advantaira.com and subscribe.